Welcome to VHIA podcast episode 310. I'm Stuart McCullough. I'm the CEO of VHIA. And joining me today is the Director of Workplace Relations Services, Tim Nagel. Welcome, Tim.
Thanks, Stuart. Good to be here.
Tim, today we're looking at some key consultation terms, and there is more than one under the new Nurses and Midwives Agreement.
It's fair to say that consultation is a term that's often misunderstood by the parties to the process, and within our sector, consultation is a common source of disputation.
So we're going to focus today on three clauses that concern consultation, and there is another consultation obligation that we'll refer to, but I'll start with the obvious question, Tim. Why is there more than one consultation term?
Yeah, so the difference is that certain events or actions require consultation to a particular level, and those requirements vary because of what's at stake. But the principle as to what consultation and what it seeks to achieve is consistent.
Well, I was just going to say, in terms of what that objective is, that consultation is a genuine opportunity to influence the decision maker. We're going to start with Clause 11, which is where we will spend the most time today. Clause 11 is entitled consultation, but I'll begin by asking you the question, when does the process under Clause 11 apply?
Yeah, so Clause 11 applies where the employer proposes a major change that may have a significant effect on an employee or employees.
So we'll get into that in greater detail in just a moment, but it's also worth noting that the clause itself begins with a note.
The note confirms that consultation applies in a range of circumstances and that Clause 11 doesn't limit when consultation is required. Specifically, the note provides nothing in this clause, 11, limits the employer's obligations to consult with HSRs under the OH&S Act.
And it's also worth noting that consultation is a key part of the occupational health and safety requirement or framework more generally. But let's get to the clause itself.
So subclause 1A goes to that point. We were discussing about when consultation is required. As you can see on screen, it states consultation regarding major change, where an employee proposes a major change that may have a significant effect on an employee or employees. The employer will consult with the affected employees, the union, and the employee's other chosen representative where relevant before any proposed change occurs.
I'm very much struck by the end of that sentence, before any change occurs. One of the common questions that we get is around employees who, for some reason, are away from the workplace. What's the obligation with respect to those who are absent?
So being away doesn't disentitle you to the right to be consulted with. And subclause B deals with that, and it says consultation will, where reasonably practicable, include consultation with those who are absent on leave, including on workers' compensation or parental leave.
And I'll just add to that subclause C, which provides the employer will take reasonable steps to ensure that employees, health and safety representatives where relevant, and the union can participate effectively in the consultation process. Tim, that phrase there, what does that mean?
So a practical example is that the union may want to meet with the affected employees to discuss the proposed change, and the employer should do whatever is reasonable to support that.
If I go to Clause 11.2, it includes a range of definitions, which I'd like to focus on a few of them. We started this podcast by saying that consultation is often misunderstood. For that reason, the term consultation has itself been defined.
Yeah, that's true. So that's at Clause 11.2. And it defines consultation as follows. Consultation means a genuine opportunity to influence the decision maker, but not joint decision making. It is not merely an announcement of what is about to happen.
And that definition is from a decision of Commissioner Smith, as he was then, of the Fair Work Commission. We spoke earlier that this obligation applies in the context of a major change that may have a significant effect. How are those two terms defined?
So major change is defined as follows. Major change means a change including a temporary or urgent change in the employer's program, production, organisation, physical workplace arrangements, structure or technology that is likely to have a significant effect on employees.
What's interesting for me about that definition is that it concerns not only what the change is to, that it's to the program, production, etc., but also to the effect that it has. So what is a significant effect?
So a significant effect is defined in 11.2 in a manner that is indicative rather than exhaustive. So you can see that on screen. So significant effect includes, but is not limited to, 1, termination of employment, 2, changes in the size, composition or operation of the employer's workforce, including from outsourcing or skills required, 3, alteration of the number of hours worked and or reduction in remuneration, 4, changes to an employee's classification, position, description, duties or reporting lines, 5, the need for retraining or relocation, redeployment, transfer to another site or to other work, 6, removal of an existing amenity and or the removal or reduction of job opportunities, promotion opportunities or job tenure.
I'll note now that there's a definition that gives examples of measures to mitigate or avert, but we'll come back to those. Subclause 3 is headed consultation steps and indicative reasonable timeframes.
It is. We mentioned at the outset that consultation is a frequent source of disputation. The purpose of this subclause and subclause 4 is to provide a map that people can rely on to drive the process forward.
So the indicative timeframes then are exactly that. They give a guide, but they aren't binding. They may be shorter, they may be longer, depending on the type of change proposed.
Exactly. So subclause 11.3 starts by saying consultation includes the steps set out below, which is making the point that it is not necessarily exhaustive. Subclause B is in effect an explanation about the purposes of the step. So you can see on screen now at B, timeframes for each step must allow a party to consultation, including a representative, to genuinely participate in an informed way, having regard to all the circumstances, including the complexity of the change proposed and the need for employees and their representatives to meet with each other and consider and discuss the employer's proposal. The timeframes in this clause are indicative only, and in the case of a temporary or urgent change, a shorter timeframe may be appropriate.
So that provides us something of a segue to the timeframes themselves, Tim.
Yeah, and they're set out in a table, which you can see on the screen at the moment, with the steps, the actions, and the timeframe or the indicative timeframe. So step 1, employer provides change impact statement and other written material required. 2, written response from employers and or unions, and that's usually within 14 days of step 1. Step 3, consultation meetings convened, 7 to 14 days of step 2. The first meeting at step 3 does not limit the number of meetings for consultation, which is an important point to understand. 4, further employer response where relevant after the conclusion of step 3. Step 5, alternative proposal from employees or union, and that's within 14 days of step 4. Again, these are indicative dates. And finally, step 6, employer to consider alternative proposals consistent with the obligation to consult and, if applicable, to arrange further meetings with employees or union prior to advising the outcome of consultation. And again, the indicative timeline is 14 days within step 5.
So it should be noted that whilst this agreement has indicative timeframes, that's not true for all of the agreements within the sector.
No, a small number of unions resist timeframes, but that doesn't mean that consultation process shouldn't be considered timeless.
Or that it should be considered timeless.
It should be considered timeless.
It is not timeless.
No.
Yes, the absence of indicative timeframes doesn't mean you can take as long as you wish.
It's not a Cindy Lauper song.
No. Let's get to the steps at 11.4.
So 11.4a concerns step 1, and it reads as follows. So change impact statement, which is, again, step 1. Prior to consultation required by this clause, the employer will provide affected employees and the union with a written change impact statement setting out all relevant information.
All right. So just with that reference to all relevant information, I do feel that there may be a list coming on.
Yes, as opposed to arguing about what the relevant information is, there is a list to consider. So it is a non-exhaustive list, though. So it includes the details of proposed change, the reasons for the proposed change, the possible effect of the proposed change on employees, workload and occupational health and safety matters, such as those set out in Clause 99, which is the OHS risk management, where occupational health and safety impacts are identified. Risk assessment of the potential effects of the change on the health and safety of employees must be undertaken in consultation with health and safety representatives, and the proposed mitigation actions to be implemented to prevent such effects. That's not the end of the list, but I want to pause at that point to note some slight clarifications regarding the OHS provisions. So other information to be included in a change impact statement include the expected benefit of the change. So what is the employer seeking to achieve? And measures the employer is considering that may mitigate or avert the effects of the proposed change. It goes on to Roman numeral 5, 6. If relevant to the proposed change, existing and proposed position descriptions, including new roles, those of the affected employees or managers where reporting lines change. 7, the right of an affected employee to have a representative, including a union representative, at any time during the change process. And finally, subclause 7, other written material relevant to the reasons for the proposed change, such as consultant reports, excluding material that is commercial in confidence or exposes the employer to unreasonable legal risk or cannot be disclosed under the Health Services Act 1988 or other legislation.
Thank you for taking us through that list, Tim. I'll take you back to Roman numeral 5. And we had mentioned before we would come back to this, just in terms of measures that may mitigate or avert a major change.
So these are things that an employer is considering to reduce or avoid the impact of the major change. For example, maintenance of salary or accruals, retraining, redeployment are some examples of actions that may avoid or reduce the impact of major change on affected employees.
I think the key thing for that, for me, is that those measures aren't purely reactive. That is, an employer needs to have turned their mind to those issues at the point of a change impact statement at the beginning. I want to move on to subclause B, which states any concerns by an affected employee or their representative regarding the change impact statement, whether the change impact statement complies with clause 11.4, will be raised as soon as practicable and before step 2. So what is that seeking to do?
Yes, to prevent a circumstance where a party asserts that there has been a deficiency in the change impact statement right at the end of the process, which employers often think is simply for the purpose of preventing or delaying the implementation of the change. So there's an onus to raise any concerns at the time to avoid that circumstance from eventuating.
All right, that takes us through step 1. Step 2 at 11.5 provides that following receipt of the change impact statement, affected employees and/or the union may respond in writing to any matter arising from the proposed change.
Yeah, so it's important to highlight that the use of the term may here. They may respond in writing, but not responding in writing doesn't result in a breach of the agreement.
Tim, I'll ask a provocative question. Why would a party respond in writing?
So they may seek clarification, propose an alternative way of meeting the objective, propose alternative or additional measures to mitigate or avert. There's a range of reasons that they will record their response in writing.
And step 3 concerns meetings.
Yes, it provides the following. As you can see on screen, 11.6 is meetings, which describes step 3. So A, as part of consultation, the employer will meet with the employees, the union and other nominated representatives, if any, to discuss 1, the proposed change, 2, proposals to mitigate or avert the effects of the proposed change in any matter identified in the written response from the affected employees and or the union. B says that to avoid doubt, the first meeting at step 3 does not limit the number of meetings for consultation.
Okay, so whether it's from a written response from affected employees or their representatives or from the consultation meetings themselves, the employer then has an obligation to consider the matters that have been raised.
Yeah, that consideration is at step 4. As you can see on screen, 11.7 says the employer will give prompt and genuine consideration to matters arising from consultation and will provide a written response to the affected employee's union and, where relevant, other representatives.
So prompt and genuine consideration and the provision of a written response. What kind of things might indicate prompt and genuine consideration?
So prompt really goes to timing. And in terms of genuine consideration, that's demonstrated by the written response engaging with the matters raised.
I always think that genuine consideration can perhaps, where possible, best be demonstrated by an amendment to the proposal arising from the feedback.
Yeah, that's true. But although we need to remember that the nature of the feedback doesn't always lend itself to an amendment. So amendment may
Yes.
occur, but is not required.
Yes. That said, step 5 does provide a right to submit an alternative proposal.
It does. So 11.8 represents step 5. The affected employees, the union, and other representatives, where relevant, may submit alternative proposals which will take into account the intended objectives and benefits of the proposal. Alternative proposals should be submitted in a timely manner so that unreasonable delay may be avoided.
So interesting to note the obligation to be timely. I think it would be surprising to some that alternative proposals are often not made. As a more general point, Tim, and some responses to proposals can be more in the form of a blanket opposition, and the opportunity to put forward an alternative isn't always taken up. And that's speaking really more to the sector rather than this specific agreement.
Yeah, we go back to the definition of consultation not being agreement. Step 6 of the consultation process is described at 11.9. And that really goes to the outcome of the consultation. So the employer will give prompt and genuine consideration to matters arising from consultation, including an alternative proposal submitted under clause 11.8, and will advise the affected employees, the union, and other nominated representatives, if any, in writing the outcome of the consultation.
All right. So I feel at this point, Tim, we may be building up to another list.
Correct. So the written advice about the outcome of consultation will include the following. So this is a will. So A, whether the employer intends to proceed with the change proposed. B, any amendment to the change proposal arising from that consultation process. C, details of any measures to mitigate or avert the effects of the changes on affected employees. And D, a summary of how matters that have been raised by affected employees, the union, and their representatives, including in the alternative proposal, have been taken into account.
I'll also observe that this subclause has a note pointing to clause 11B in the case of amalgamation of wards. We'll speak more about that in a moment, but what about disputes, Tim?
So subclause 10 has something of a statement of the obvious in many ways. So consultation disputes is the heading, and any dispute regarding the obligations under the clause will be dealt with under the dispute resolution procedure at clause 13 of this agreement.
So that's clause 11 concerning major change and significant effects. But clause 11A, which follows it, is also about consultation.
It is. So clause 11A is a term that's required to be included in an agreement by the Act. Otherwise, the default provision applies.
So first things first, the practical question for most members is when to use clause 11A rather than clause 11.
So that's addressed in a note under the heading, which states as follows. This clause applies where a change to regular rosters or ordinary hours of work, which may impact upon an employee, particularly in relation to their family and caring responsibilities, does not constitute a major change in accordance with subclause 11.21.
So two things jump out. Firstly, that we're talking about changes to specific things, namely regular rosters and ordinary hours of work, but also that we're talking about those things where the changes do not constitute a major change.
Yes, these are changes to regular rosters and ordinary hours of work that fall outside the scope of clause 11, but where consultation is still required.
But it would be fair to say that the steps required for consultation under Clause 11A are less complicated and more direct.
That's right. It doesn't require a change impact statement or have the steps set out in Clause 11. The Clause 11A does provide for a process. So 11A.1, you can see on screen there, where an employer proposes to change the employee's regular roster or ordinary hours of work, the employer must A, notify the relevant employee or employees of the proposed change, and B, consult with the relevant employee or employees and their representative, if any, about the proposed change as described below.
And I think it's worth emphasising that consultation here means the same thing as it does in the previous clause. That is, it is a genuine opportunity to influence the decision maker.
Yeah, that's right. So subclause 2 goes on to more detail about what that process requires. So 11A.2, as soon as practical after proposing to introduce the change, the employee must A, discuss with the relevant employees the introduction of the change, and B, for the purposes of the discussion, provide to the relevant employees all relevant information about the change, including the nature of the change and when that change is proposed to commence, and information about what the employer reasonably believes will be the effects of the change on the relevant employees. 3, information about any other matters that the employer reasonably believes are likely to affect the relevant employee. And finally, C, invite the relevant employees to give their views about the impact of the change, including any impact in relation to their family or caring responsibilities.
So it's important to note that this process goes to identifying the potential impact on family or caring responsibilities, and that concept really underpins the clause.
It does. So subclause 3 provides that the employer is not required to disclose confidential or commercially sensitive information to the relevant employees. It's really focused on that impact on the employee.
And subclause 4 requires that the employer must give prompt and genuine consideration to matters raised about the change by the relevant employees and consider health and safety impacts, including fatigue. Again, prompt and genuine consideration is one of the requirements, including considering health and safety impacts. But subclause 5 defines the term relevant employees. But I want to get to subclause 6.
Yeah, so subclause 6 is in the form of an exclusion. So 11A.6 reads as follows: the requirement to consult under this clause does not apply to an employee where the change to an employee's regular roster or ordinary hours of work is as a consequence of the employee's irregular, sporadic, or unpredictable work hours, self-rostering, or where permitted, a rotating roster.
Okay, so it's not disrupting business as usual, as it were. The last subclause in 11A at 11A7 provides that the provisions of this clause 11A are to be read in conjunction with the terms of the engagement between the employer and employee and other agreement provisions concerning the scheduling of work and notice requirements. What does that do?
Really, it's saying that the ability to change is not unfettered, and that, as always, it's necessary to consider other parts of the agreement, such as those concerning rosters and the contract.
So that takes us to the third of the 3 clauses that we're focusing on today, Clause 11B, which has the title, No Amalgamation of Wards Without Agreement of ANMF and Employer. It's less a title, it's more a statement.
Yeah, this clause adds to Clause 11 for a particular kind of change, namely a change that amalgamates wards. It provides as following: 11B.1, a proposed amalgamation of wards will be subject to consultation under the consultation provision, save that the clause will not apply, and instead the dispute will be notified to the statewide industry panel under Clause 14.
So disputes on this subject go to somewhere other than the general disputes provision at Clause 13. They go to the panel under 14.
Correct.
All right. And if I go to 11B2, during the life of the agreement, there will be no amalgamation of wards that will result in an increase in workload for the employees working in those wards who are covered by the agreement or increase to patient risk in those wards without agreement of the ANMF and the employer. What's interesting is it's referring to an amalgamation of wards that has a particular effect, namely an increase in workload of employees or an increase in patient risk. Tim, given we have nurse and midwife to patient ratios, where would an increase in workload arise in the event of an amalgamation of wards?
So it's true. It's true that there are ratios that will respond to increasing patient numbers. The exception is in terms of the number of nurse managers. They're set per ward rather than per patient.
Which means that any proposal around ward amalgamations should address nurse manager workload. And Tim, the final subclause.
So that states as following: the statewide industry panel will have regard to the department's guidelines, which will reflect historical and contemporary practice and standards.
All right, so that gives us something of an anchor in the event of a dispute. So that completes our overview of the consultation provisions. Tim, is there anything else to say?
Yes, just to again emphasise that there are other consultation obligations that exist outside the three clauses we've talked about today. We've already mentioned occupational health and safety, for example.
And I might add to that clause 99.4, which is titled Central Building Consultative Committee, which concerns consultation over construction of new or significantly changed work areas. Tim, thank you for taking us through some of the consultation obligations arising under the new Nurses and Midwives Agreement.
My pleasure. Thanks, Stuart.
VHIA.com, VHIA.com, VHIA.com.